Well, I think I'll let the majority speak for themselves, but what they argued is that they think that this deal was the best that they could get.
And you also make the point in your statement that the FTC is unique in that it doesn't have an independent litigating body. It would refer this to the DOJ. It is now, in a way, in the hands of the DOJ. The DOJ has opened its own broad investigation. Are you hopeful that the DOJ takes action? Or are you hopeful that perhaps the FTC will go on and take further action on Facebook and maybe some other big tech names?
Well, I think that's actually a separate issue. What the DOJ announced yesterday sounded more like an antitrust review. With respect to our particular privacy case, the DOJ joined the announcement today saying that they would file it. And while I objected to the settlement and I objected to the release of liability that it had in it with respect to privacy violations, it didn't release the company from any antitrust or competition investigation. So to the extent that those exist either at the DOJ or at the FTC, those could continue uninhibited.
So what happened in terms of the FTC's decision, the 3-2 decision? It doesn't preclude the FTC from taking further action. So in other words, even though you may view this as a slap on the wrist for Facebook, it may still face further investigations by the FTC specifically.
It doesn't preclude the agency from taking further action on antitrust issues or on consumer protection issues outside the scope of the order that we were trying to enforce. But it does immunize the company and its executives from any further enforcement with respect to any allegations of violations of its previous order where it promised not to make misrepresentations about user privacy.
By any standard, $5 billion is a lot of money. It may not be a ton of money with respect to Facebook's revenue stream. What would you have liked to have seen by way of remedy for the conduct that is being sanctioned today? What would you have preferred?
So what I said in my statement is that I feel strongly that a remedy would need to give us confidence that Facebook is not going to engage in the kind of behavior that led it to be under order in the first place or that led it to violate the order in the second place. And for me, that included at least two key provisions. The first was some limitation, some substantive limitation on how Facebook collects, shares, and uses data. And the second is public transparency and public accountability. And while the order does require a lot of internal reporting to Facebook and reporting to the FTC, all of those things would be non-public. And I would prefer to see public accountability. If not in the order itself, then I thought litigation would be a really effective way to ensure that public transparency and public accountability.
On Capitol Hill, Rebecca, this seems like a bipartisan issue. You have senators and congresspeople on both sides who want to see Facebook held accountable in some way, and yet this was a decision at the FTC that was right along party lines, 3-2. You're one of the two, obviously, Democratic commissioners who dissented. What can you tell us about the thinking within the FTC and how this sort of political divide within the agency could shape further pursuit of Facebook?
So candidly, I know it was a party line vote. I don't think of this as a partisan issue or a political issue. I think each of us looked at the facts and the case and the law and arrived at our own independent conclusions about what the agency should best do. I'm someone who advocates all the time for the FTC to have more resources and more authority, and I think we do need a federal privacy law, and nothing today changes that. But I also think that today we should use the authority and the resources we have to their fullest extent, and I would have preferred to see us take Facebook to court.